Bombshell tonight in the Nolan Wells investigation. Tonight, the timeline seemingly blows up. This as Nolan's mother is investigated. Why? And tonight, possibly even more important, where is Nolan's phone?
First, a young man separates from his phone, something no teenager typically does, and disappears from a boat full of friends on Horn Island. Second, his mother notices a complete absence of digital activity during those critical hours. No texts, no snaps, nothing, which struck her as profoundly wrong. Third, a speedboat leaves the island shortly after he vanishes, and when it reaches the mainland, Nolan is not on it.
A Bertram boat was seen leaving shortly afterward at a high rate of speed. Pretty certain Nolan Wells was part of a group that was, quote, almost fighting around 5 p.m.
I'm on the side of finding out why everybody got back to the mainland except Nolan.
Fourth, his friends claim they returned his phone and keys to his mother that same night. But conflicting accounts emerge about whether the phone was ever handed to authorities for forensic analysis.
At all. They do not have Nolan's phone. They haven't had access to Nolan's phone. The Jackson County Sheriff's Department has it. So how can you say that there's text missing or there's photographs missing? Our boys had no reason to do anything with Nolan's phone other than give it back to Christine and her friends later that night. So anything about missing text messages or Snapchats is completely.
Fifth, a grand jury convenes to investigate, yet the official cause of death remains officially undetermined, and we're left parsing statements from lawyers and social media personalities instead of forensic conclusions. This is the Nolan Wells case, and what we actually know is far messier than what's being claimed across social media and YouTube. Let's separate documented fact from the mythology growing around it. Start with the basics. Nolan Wells was 18 years old. On the day in question, he was with a group of young men on a boat, the Triton, headed to Horn Island in Mississippi. According to the accounts documented in interviews and legal filings, Nolan left his phone on the boat when he went to the island. This detail matters because, as observers have noted, young people typically don't separate from their phones. But it happened. He left it behind. Now, the question of why and what happened next is where the documented record becomes contested. His mother, Christine Wells, noticed something that day. She observed, according to statements given, that there was no communication activity on Nolan's phone while he was at Horn Island. No text coming in or going out, no snapshot activity, no digital footprint. She found this odd. And here's where we have to be precise. She found the absence of activity suspicious. She did not claim she had examined deleted files or found evidence of tampering. She noticed a silence. That silence, though, became fuel for theories. The complication is immediate and real. When something is not present, observers can imagine many causes for its absence, and they have.
Especially complicated cases, I would start out the trial with a big jar full of water and silt. And I had it sitting big on my counsel table, day one, right beside my Bible. And in closing arguments, the first thing I would do when I started closing arguments, I'd take that jar and shake it. And it would get very murky. You couldn't see anything. And I'd sit it down on my counsel table and argument would commence. And by the time I had gone through all the evidence, I'd go over to my table, pick it up, and say, see, it's not muddy anymore. It's crystal clear what happened. My point is, we don't know. So all the haters attacking you, attacking me, attacking the cops, attacking the friends, attacking Nolan's mother, for Pete's sake, we don't know. It's unjustified.
The boat returned to the mainland at high speed. Everyone on the Triton except Nolan made it back. According to Tyler Cox, the attorney representing the young men on the boat, they told Christine Wells immediately that they had Nolan's phone and his keys. Cox states they returned both items to her that same evening. Cox also states, and this is important to note, that the boys had no reason to access, alter, or interfere with the phone at any point. They claim they gave it back and cooperated fully with authorities. This account is one side of a contested narrative. On the other side, statements attributed to the family's counsel indicate, as of the time these interviews were recorded, that while they were prepared to cooperate, the phone had not yet been handed over to law enforcement for forensic extraction. These are not compatible statements. One or both contain inaccuracy, or the timing is being misrepresented.
Tyler Cox stating, I don't think they cooperated at all. I think he's talking about Nolan's family. They, I guess the sheriff's office, haven't had access to Nolan's phone. Well, can't they subpoena that? It's called a subpoena ducis tecum. You're familiar with those. You've testified in court. A subpoena ducis tecum is, we hear about subpoenas for testimony. I've been subpoenaed. Yes, go to court and tell the truth. A subpoena ducis tecum is for an item, an object, a document. The sheriff can give out a subpoena ducis tecum or get a warrant for an object. So, you don't have it? Fine, get it. Next. So, how can you say I'm quoting, how can you say there's no text message or photo, as a text message or photos missing? Our boys had no reason to do anything with Nolan's phone other than give it back. So seeing anything about missing texts or Snapchats completely false. Well, according to the mom, Officer Tatum, she says that there was nothing sent out while Nolan was at Horn Island, which she found very odd. I have no reason to disbelieve her.
We don't know which. Here's the media literacy point that bears stating plainly myth travels faster than the documented record. By the time this Nancy Grace episode aired, claims had circulated online that the phone had been deleted, tampered with, that evidence had been destroyed. Nolan's mother never made that claim. She said she noticed an absence. The friends never acknowledged tampering with the phone. Yet the mythology of deletion had become hardened in public discourse. People were sharing theories as fact. Social media was divided into camps. Those who believed the friends, those who didn't, those who suspected the family. The actual forensic analysis, the thing that could settle whether anything was deleted, had not been conducted. And the grand jury investigation was, at the time of this episode, ongoing. In other words, the court of public opinion had reached verdicts the court of law had not. Now consider the phone itself and what it could reveal.
His belongings. Well, it
Nancy,
can mean anything that does not equal, we have not handed over the phone, but hey, you know what?
Nancy, it's been weeks.
You say tomato, I say tomato, because it kind of doesn't matter, and I'll tell you why it doesn't matter. Actually, I'll let an expert tell us why it doesn't matter. To Heather Barnhart joining us, digital forensics expert with Celebrite. We learned all about Celebrite during the Alex Murdaugh trial. That's how we got everything off of his dead, murdered son's phone. And the SANS Institute, S-A-N-S. She is one of the preeminent digital forensic experts in the country. She helped crack the Brian Kohberger case, and she is co-author of Practical Mobile Forensics, now in its 4th edition. That means that many people have used it. Heather, thank you for being with us. If the phone,
Thank you for having me.
I don't care where it is. Okay, actually, I do care where it is. I want to know that it's been handed over. I don't have to have the phone to know what's on the phone if it's in the cloud. It looks like an iPhone to me. So my argument with Officer Tatum is academic. It doesn't matter if I can get it from the cloud. So Nolan's phone missing. So what? I can download it. I can get it.
Data will exist in the cloud if he's syncing to iCloud and third-party applications. However, having physical access to the phone is where the databases exist that will have the truth on deletion. So you really need to get a full file system extraction of his phone as quickly as possible. So if it's not handed over to authorities now, it needs to be, because this was over a month ago now.
Do you have to have the phone to do the extraction? What about the cloud?
Cloud data is different, and there's a lot of information there. There could be unique information in the cloud that's been removed from the phone, if anything was removed, but it's best to have both cloud and the phone to paint the entire pattern of behavior and to see the truth.
Heather Barnhart, please don't move. Back to Officer Tatum joining us.
Heather Barnhart, a digital forensics expert with expertise in cellular data recovery, explained to Nancy Grace that modern phones create what she called a digital trail that is extraordinarily difficult to erase. She stated, and this is documented in her expertise, that cloud data exists independently of the phone. If Nolan Wells synced his iPhone to iCloud, data sits on Apple's servers. Snapchat data, if a warrant is served before deletion occurs, can be frozen on Snapchat's servers for up to 30 days. Text messages, photos, videos, they leave traces. Barnhart emphasized that full file system extraction from the physical device is the gold standard for determining what was deleted and when. But she also made clear, you can recover significant information without the phone if the cloud was being used. Here's what this means in practice. The dispute over whether the phone was handed to authorities becomes, in a narrow forensic sense, less determinative than the public narrative suggests. If digital extraction happens through cloud services, through the family's own iCloud account, Snapchat's servers, and the FBI's legal requests, data can be recovered. And if nothing was deleted, that will show. If something was deleted, that will show too. The absence of the physical phone is a complication, not a barrier. Tanya Jordan, a technology and parental controls expert, reinforced this point. She explained that deleted photos on Apple phones sit in a recently deleted folder for 30 days.
To Tanya, we were speaking to Heather Barnhart earlier tonight. Could you explain how a snap disappears and whether it can be grabbed back out of the cloud? Same thing with DMs, same thing with text messages, photos. A lot of teens think because they hit delete, it's gone. It's not.
It's not. And with regards to Snap, if you send a photo or video and the other person hasn't opened it yet, it sits live on Snap's server for up to 30 days. Same with unread texts. Now, if law enforcement sends Snapchat a valid legal request before the message is deleted, Snapchat will freeze that data and hand it over. But if the message was already deleted before the police asked for it, Snapchat apparently cannot retrieve it.
Isn't it true, to Tanya Jordan, that modern technology can prove whether you have deleted anything? There is a digital trail showing if you have deleted photos, text messages, videos, all of that.
Absolutely. So many people don't even realize that on Apple phones, when they go to delete a photo, there's a whole folder in there called deleted photos where they live for at least another 30 days. Your digital trail is so hard to erase. It's why tech experts like myself tell you when you have old tech that you're no longer using, don't immediately recycle it. Don't throw it away. You've got to give it a water bath to fry every component inside of it, because you can dig up a digital trail very easily, and nothing disappears when you're dealing with technical aspects.
Your digital footprint, she said, is nearly impossible to erase. The technological reality is that if someone deleted something from Nolan's phone, the evidence of that deletion likely still exists somewhere in the digital ecosystem. But here's the restrained reading. We don't know if anything was deleted. We know his mother noticed no activity during his time on the island. We know there is disputed information about whether the phone was handed to police. We know a grand jury has the authority to compel the phone through subpoena or warrant if it determines the phone is material evidence. We know that digital forensics can reveal the truth if applied. But we don't know that the truth has been determined yet, or if it has, it hasn't been publicly released. This brings us to another contested claim: the polygraph tests.
Have the friends taken polygraphs?
Well, from my understanding, all but I believe one took a polygraph, and from what was told to me, that they all passed. And all of the ones that took a polygraph took one without a lawyer. And they cooperated with law enforcement. So from my understanding, everybody took
Why
a
do you say
polygraph
that's
test
from
but
what
one.
you understand? Did they tell you they took a poly and passed?
Yes, ma'am. They told me that they did it. I wasn't there. So that's why I'm saying from my understanding. They told me that all the boys except one, which is Warren, I believe, took a polygraph test. All of them did not have lawyers and did it and cooperated with police. Warren also cooperated with police. I just believe he didn't take a lot to take the test, but Warren is the young man that I interviewed. So according to what they told me, they all took a lie detector test and passed. And it's an equivalent of a lie detector test. It's not a traditional lie detector test, but it's the same theology of trying to get to if a person is lying. I don't know the name of it. It's an equivalent of a lie detector test. It's a different methodology. I don't believe it was a polygraph test. I believe they took other stressors in order to analyze if the people were telling the truth or not.
Did they take a polygraph would be...
Officer Brandon Tatum, who interviewed the young men on the boat for his YouTube channel, initially stated that the friends had taken polygraph tests and passed them. He said they cooperated with law enforcement, took the tests without lawyers, and all of them passed. This was presented as evidence of their credibility. But when Nancy Grace pressed him, the story changed. They had not taken traditional polygraph tests. They had taken a computer voice stress analysis, a different technology entirely. This is worth dwelling on because it illustrates how claims shift when examined closely. A polygraph measures heart rate, blood pressure, perspiration, eye movement.
Okay, let me just make sure clear, because I think the internet went in a frenzy about this. It's a computer voice stress analysis is what I was referring to. None of this is admissible in court, and I don't think it has the weight to concern anybody or whether or not anyone took it or not. I just thought it was important to show the cooperation that they had with the police. Even more cooperation, I believe, almost than the Nolan family. I mean, the boys have given their phones over to the FBI voluntarily, and we still haven't gotten Nolan's phone from the family to the police. So,
are you back on the phone? Because you don't know. You've already said you don't know where the phone is. It could be sitting on the sheriff's desk for all I know.
If they did it in the last 10 minutes, maybe that could be true.
Oh, so you knew before you joined us tonight that Nolan's family had not handed over the phone?
Well, I have no information to believe it was handed over. The last report from their attorneys that they hadn't handed it over.
So that was your, quote, understanding, just like you had an understanding that they took a poly and then clarified they did not take a poly. Okay, they have not taken a poly. You don't know why Warren hasn't taken a test. And a computer stress test is a voice analysis. It's not the same as a poly. You also, I asked you earlier, are you a medical examiner? And you stated no. I know you're a star on YouTube. I know you have a huge following. I know you're highly popular. I know you're a former police officer. Are you a Juris Doctor? Are you a lawyer?
No, I'm not. I've worked with lawyers.
Okay, because polygraphs are admissible in court. Bam! Providing,
Nancy, I have
providing both parties stipulate ahead of time that they will be allowed. I don't care if you've never heard of it.
Nancy is not going to. I don't know of a trial that has happened, from my understanding in recent time, that somebody put a polygraph before a jury and it was effective. I mean, there is a lot of flaws in the polygraph test.
Have you ever heard of, let's see, what was his name? Control. Oh, yeah, O.J. Simpson.
Well, that was a long time ago. I'm saying
in the civil trial and showed he was a big fat liar.
Well, what I'm saying is there has not been significant usage of polygraphs in the court of law because there's too many flaws. Even as a police officer, we don't even use polygraphs anymore. Most police departments use the computer voice stress analysis. And neither one of them,
that's not true.
I would trust. Most police departments do not use the polygraph test anymore. They're moved towards the computer stress analysis. My head of security, when he went to the police department, they used the computer stress analysis. And it's not even foolproof. I mean, I would not trust somebody to use that for anybody's statements.
All I asked you is, did they take a polygraph? You know, in the famous words of the Bard, Shakespeare.
Nancy,
we think that test too much. All I said was, did they take a poly? And the answer is,
a voice stress analysis examines vocal patterns. These are not equivalent. Importantly, polygraph results, while not admissible in most criminal trials without stipulation from both parties, are far more widely accepted than voice stress analysis, which is considered unreliable by many in law enforcement. Tatum himself acknowledged this shift, but the damage to the narrative had already been done. In social media discourse, the claim had solidified the friends' past polygraph tests. That claim, as stated, is inaccurate. They took voice stress analysis. This is an example of how details degrade in public coverage. That said, the friends did hand their phones voluntarily to the FBI. Tatum confirmed this. They did cooperate with interviews. They did not retain lawyers during initial questioning. These are documented points of cooperation.
Now, my question to you is, you're stating that the friends, I'm talking about the young men on the Triton, that the friends have handed over their phones.
Yes, ma'am. They've handed on their phones to the FBI voluntarily.
I find that very commendable, because do you know how hard it is to get people to hand over a phone? That's why you have to issue a search warrant or a ducus tecum. So they have handed over their phones voluntarily.
Yes, ma'am. According to the lawyer and according to what they told me, they said they handed over to the FBI voluntarily. And the sad part is that I wish that Nolan's phone could be evaluated, because there have been claims that had not been substantiated. And I believe that the claims should have never gone out in the public unless they were substantiated, that there was a potential that things were deleted from his phone, which put these young boys in a bad position unnecessarily. It's not fair to say that you're throwing out that things were deleted,
it's not.
but obviously mom
it's
can't
not.
determine if they were deleted because she couldn't do a forensic investigation on the phone, so she really don't know. Which I'm not
Unless
knocking
she
her as her
looked in the
baby.
deleted file and found things.
Well, she within
could have looked in
Nancy,
the deleted file and found things, and we don't know
And
that
she would
happened.
have told
And I
the-
agree with you. I
But
think
Nancy,
you
she
got
would have
me
told the
wrong. I
world.
think you got it backwards, Tatum. Nobody.
she would have told the
on Crime
world
Stories-
if she would have found. She would have told the world, Nancy, if she would have found certain things that were actually deleted. She would have come out. I'm sure Benjamin Crump would have come out, and I would commend her to come out and encourage her to. If she saw that a picture of Nolan was deleted, a text from Nolan was deleted specifically talking about or inferencing certain things. If any of those things had happened, I would guarantee it should be criminal if they would not turn it over to law enforcement, so law enforcement can evaluate the phone and see if there were individuals communicating or deleting communication, because that is a crime. We just seen that happen in Texas, where young boys, there's a young man that drowned, they go and delete stuff off his phone, throw his clothes in the water, and they were arrested for tampering with evidence. And so if there had been deletions on the phone, even if there hadn't been a determination that anyone had murdered Nolan, tampering with evidence or deleting evidence, potential evidence, is a crime. And so the fact that the family, from my understanding and what the lawyers have said, that they haven't given this information over to law enforcement for them to evaluate, it's very troubling to me.
It's notable, though, that cooperation and guilt are not inverse. Cooperation and innocence are not equivalents either. Innocent people cooperate. Guilty people sometimes cooperate too. Now, the medical and forensic picture. Nolan Wells' body was recovered. 2 medical examiners have examined the remains. Both have ruled the cause of death undetermined, officially. One examiner stated that toxicology was pending at the time of the initial report. Another examiner noted that certain organs were not available for examination, which limited the forensic conclusions that could be drawn. By the time of the Nancy Grace episode, word had come that the autopsy report was complete. This typically means toxicology, histology, and other tests had been processed. But the cause of death had not been publicly released. Joe Scott Morgan, a death investigator with over 10,000 death investigations in his case history, explained that drowning can be difficult to conclusively determine because a head injury preceding the drowning, any alteration of consciousness, can accelerate fatal outcomes in water. In other words, drowning as a cause of death doesn't exclude foul play. A person could be struck, fall unconscious into water, and drown. Alternatively, a person could fall overboard drunk or from accident and drown. The water is the final mechanism, but what precedes it matters legally and investigatively.
Brought that up, Tatum. To Joe Scott Morgan, death investigator, it could be that he did drown But that does not rule out foul play. It doesn't rule it in. It doesn't rule it out. Explain.
Yeah, you're correct. I mean, drowning, just so you understand, if somebody, say for instance, has a head injury, right, and they fall into a body of water, all right, that can lead to drowning, right? Because they might still be unconscious but capable of breathing. And of course, if you're in a water environment, you're going to be taking on water. I've worked cases where water has actually been weaponized as a means to take someone's life. But I've also worked, Nancy, a lot of cases involving accidental drownings where people fall over the side of boats. I've even had homeless guys that have passed out face down in mud puddles and have drowned. You never can predict, how any of this is going to happen. All we can do in the morgue, the medical legal community, is assess what we see at that moment in time. When we're trying to look at the lungs, we're trying to look actually at the inner ear. That's one of the areas that we go to with drowning. And we try to assess the brain as well, because you can have the brain begin to swell in these certain circumstances. So there is a huge recipe that goes into this when you're trying to do a fatal diagnosis here. When you're trying to come up and make this assessment, you want to do it necessarily. I think it's best you try to do this independent of maybe what the police are saying, what friends are saying. You objectively look at the science of what's before you, and then after that, you go back in and factor in some of the circumstantial information.
You're seeing video given to us by Officer Tatum's show. Look at all the people out there. Speaking of witnesses, Joe Scott, you dead on. Thanks, Tatum. Because you know what? Somebody saw something, somebody knows something, and they are not coughing it up. And we're going to keep on until...
The boat itself, the Triton, has not been searched with cadaver dogs, according to Tatum. This became a point of contention in the interview. Benjamin Crump, an attorney involved with the family's interests, apparently expressed interest in having cadaver dogs search the boat. Tatum stated that Crump declined when the opportunity was presented.
But Tatum, the boat, has the boat been searched by cadaver dogs and scent dogs?
The boat, from my understanding, has not been searched, and the cadaver dogs were made available for Benjamin Crump to utilize them to do a search on the boat. They refused.
Crump is not supposed to use the dogs.
There is no reason to search
everything on Crump.
Listen, Nancy, there's no reason if there's not any evidence of a murder, there's no reason for them to use the cadaver dog. That's how this works.
True.
There's none of these individuals they do not have any expectation that there was any murder that occurred. It's just other people are putting that out to the world. The police department is not investigating the murder. These boys are not suspects.
I agree, they're not suspects. They're not persons of interest. They're not suspects. They haven't been charged.
However, Tatum also clarified, importantly, that Crump and the family cannot legally compel a search of a private boat. Only law enforcement has that authority.
Philip Dubé joining me. He is a veteran trial lawyer, a defense lawyer. He's joining me out of L.A. He practices criminal and constitutional law. Dubé, I don't want to hear either a prosecution or a defense side. A citizen cannot force a search on somebody else's boat. So Crump or Mrs. or Nolan's mother, they cannot force a cadaver dog or a scent dog search on the Triton. Law enforcement needs to bring out a cadaver dog and a scent dog. It's just real simple. It's not hard. Do you agree? They are the ones with authority to do that.
Of course, a lot of these thought leaders and crusaders, the thought leaders and the crusaders can all request it and make sure that there's an in-depth, thorough investigation, but they cannot physically and personally initiate it or enforce all the procedures that are necessary to get that underway. One thing they can do, though, is go to the DA's office and ask that it be included as part of the grand jury investigation. Because believe me, Nancy, a grand jury starts investigating and wants all of these materials, including access to the boat, access to the cell phone, it's going to happen. Otherwise, they will suffer the pains of contempt of the grand jury.
Dubé, my point is, Crump, nor Nolan's mother, nor anybody on their team can issue a subpoena or a directive or give permission for somebody else's boat to be searched. So when that was put to Crump, he doesn't have the authority to do that. He's a lawyer. He knows that. And it's not the friend's prerogative either. It's law enforcement needs to go do it.
Correct.
I can't come search your home. That would be trespass.
Correct.
Law enforcement has to do it. That's a yes, no. I don't need a legal discourse. Yes or no?
They can request it, they can push for it, but they cannot execute it. If law enforcement believes the boat is material evidence in a criminal investigation, they can obtain a warrant and search it themselves. The fact that the boat has not been searched is either because law enforcement does not believe it's necessary, or because such a search has not yet occurred. We don't have public information as to which. Again, absence of action is not the same as absence of suspicion. It's just absence. Here's the genuine open question that the documented record doesn't fully resolve. Why would a group of friends, described as lifelong close companions of Nolan Wells, cooperate this extensively, handing over phones, submitting to voice stress analysis, offering boat access, while simultaneously maintaining that they had nothing to do with his death if there is any possibility of criminal liability? One reading is straightforward. They're innocent, they know they're innocent, and they're demonstrating that through cooperation. Another reading is more strategic. Cooperation and innocence are sometimes identical, but they're not always. People cooperate for legal reasons to avoid the appearance of hiding something. The question worth sitting with is, what would change your assessment of their credibility? Is it a traditional polygraph rather than voice stress analysis? Is it the physical search of a boat? Is it the phone being handed to authorities? Or is it the cause of death being publicly released? Each of those is a discrete evidentiary step. None of them have fully occurred yet, at least not in any public way. This is worth your thinking through in the comments below. What would constitute sufficient evidence to you? What single piece of information would shift your assessment? Now, the underexplored angle. The media focus has been on the friends, on the phone, on cooperation and lack thereof. What gets less attention is the grand jury process itself. A grand jury in Mississippi, like those across the country, has investigative authority. It can subpoena witnesses, documents, physical evidence. It can compel testimony. If the grand jury wants Nolan's phone, it can demand it. If it wants the boat searched, it can demand that too. If it wants toxicology results, autopsy reports, cell tower data, financial records, it has that power. The grand jury is not bound by the informal negotiations between lawyers and media personalities. It operates under legal authority. And crucially, grand jury investigations are largely secret. Proceedings are sealed. Witness testimony is not public. Evidence presented is not disclosed to the public until or unless an indictment is brought or the investigation is formally closed. This means that the information available to Nancy Grace, to Tatum, to the family's attorneys, to online observers, is a fraction of what the grand jury likely knows. The grand jury may have already obtained the phone. It may have already had the boat searched. It may already have forensic results. And we wouldn't know it. The public narrative is playing out in daylight, in interviews and speculation. The actual investigation is happening in a sealed courtroom. This is often the case with investigations of this nature, and it's worth remembering.
Well, you hit the nail on the head right there, and you answered a very serious and critical question, and that is, there is a grand jury. Everything Tatum is saying and everything I'm saying, you know that phrase in the Bible, Tatum? We are now looking through a mirror darkly. We're looking through a very murky, grimy glass because we don't know. You are saying one thing. I'm questioning that because we don't know. And in the middle of it all, we have got a dead body of Nolan Wells. I don't want to get tangled up in arguments and vitriol that detracts from finding the truth. And I don't take anybody at face value. I don't suspect anybody, and I suspect everybody. I can't tell who's telling the truth. But we will, God help us, find out what happened to this young man.
The people with the most information, the grand jurors, the prosecutors, the investigators, are the ones saying the least. Finally, let's be clear on what we're uncertain about. We don't know with certainty whether the phone was handed to authorities. We don't know with certainty whether anything on it was deleted. We don't know with certainty what the cause of Nolan Wells' death was, though we know the autopsy is complete. We don't know whether the boat has been searched by law enforcement, though we know it hasn't been searched by dogs offered by someone outside the investigative chain. We don't know whether the friends are telling the complete truth, the partial truth, or something else. We don't know whether the family's hesitation to hand over the phone is protective instinct, legal advice, or something else. What we do know is that Nolan Wells is dead. We know a grand jury is investigating. We know that digital forensics can likely determine whether data was deleted. We know that law enforcement has tools to compel evidence if they believe it's material. And we know that speculation in the court of public opinion moves faster than justice in the court of law. The Nolan Wells case is ongoing. The grand jury investigation will likely continue. If an indictment is brought, we'll have clarity. If the investigation closes without charges, we may never have complete clarity because grand jury records can remain sealed. The technological capability to know what happened exists. The legal authority to compel the technology exists. What remains is the actual execution of that process and the public release of findings. Until those occur, anyone claiming certainty that the friends are guilty, certainty that they're innocent, certainty about what was deleted or preserved, is engaging in speculation, not analysis. Follow this case as it develops.
Think you know anything. Please dial 228-769-3063 tonight. We remember American hero Sergeant Kyle Robert McKee, U.S. Army, killed in the line of duty, leaving behind a beautiful wife turned widow, Lauren, and 3 children, Jackson, Canaan, and Ella. American hero, Sergeant Kyle Robert McKee. Thank you to our guests, but especially to you for being with us tonight in our search for the truth of what happened to Nolan Wells.
Share in the comments what you think would constitute sufficient evidence to settle your own assessment. And join us for the next case, where we'll ask the same questions. What do we actually know, and what are we just guessing at?